Welcome back. So 2 criminal trials hang in the balance as the Supreme Court of Appeal hears bids to have extraditions declared unconstitutional and invalid. Thabo Bester's alleged jailbreak accomplice, celebrity doctor Nandipha Magudumana, awaits judgment in her bid to appeal a Free State High Court ruling dismissing her application to have her arrest and subsequent extradition declared unlawful. Meanwhile, former Premier Ace Magashule's ex-secretary Moroadi Cholota is also preparing to file papers challenging her extradition from the United States to face charges relating to the 255 million rand Free State asbestos eradication project. Newzroom Afrika's Mnisi reports.
Dr. Nandipha Magudumana, her alleged boyfriend Thabo Bester, and their co-accused were meant to return to court on Monday. Proceedings have been delayed due to a parallel litigation which is still ongoing. Parties are said to have convened in January for discussions on the feasibility of the trial commencing.
We had predetermined dates and we then agreed that to move the matter for trial to later on the 21st of July 2025. So that's where we are. This is largely because of the outcome of SCA, which we are still awaiting.
Magudumana's Supreme Court of Appeal challenge is largely premised on whether she consented to return to South Africa while allegedly on the run in Tanzania. The Free State High Court found that while her extradition was disguised as a deportation, it wasn't unlawful due to consent. Magudumana's lawyer says the outcome of the litigation in the SCA has a direct impact on the criminal trial.
The court where we are currently will not be in the position to exercise criminal jurisdiction over my client, based on the fact that we would have argued that the NPA would not have brought the accused to court through legal or lawful means. So the process would have been contaminated.
In a separate matter, Ace Magashule's former personal assistant, Moroadi Cholota, claims that the state gave American authorities false information, which resulted in what she claims is her unlawful extradition to South Africa. She argues that the criminal court can't try her on this matter, as the state would be benefiting from a tainted process.
There are 2 ways of looking at it. The first one is they'll obviously say, there's a school of thought that will say there's a Stalingrad defense, which was mostly named in the Zuma cases or mostly known in the Zuma cases, where you use every strategy you have to delay the processes and so forth. But then there's a school of law or school of thought that will say this matter has constitutional issues that need to be raised. Therefore, the applicants or the accused, depending on where you're looking at it, they will then take the matters to court to be able to exercise their constitutional rights. So I think more for me is the constitutional rights that they are trying to exercise.
While the court agreed that the state relied on false information, it declined her application on the basis that these were issues to be raised in the trial court during the pleading stage. It said she could argue that the court can't exercise criminal jurisdiction due to the unlawful extradition.
I'm interested in Section 2 of the Constitution that says the Constitution is a supreme law of the country, and any act or law that is inconsistent to the Constitution is invalid. So when we look at both of these cases, will the court look at the fact that how the decision was reached to bring back Dr. Magudumana and Ms. Cholota to South Africa? Was it based on legal ways that are consistent with the Constitution? So that's a question. And if not, obviously the court will have to decide whether it was the right thing to do from a constitutional perspective.
Cholota's trial date remains set for the 15th of April, but it remains unclear if it will proceed given the looming litigation. Meanwhile, Magudumana is awaiting the SCA to see whether she'll stand trial on the 21st of July. For Newzroom Afrika on Channel 405, I'm Mnisi in Johannesburg.